You're listening to 106.9 at Tune FM, and today for World Book and Copyright Day on the 23rd of April, I'm speaking to Dr. Wellet Potter and Dr. Sophie Masson about books, copyright, and all things in between. So thank you both so much for joining me today.
Thank you for inviting Ash.
So, I guess just to get us sort of started, I'll pass over to the both of you to sort of talk a little bit about your expertise and your backgrounds in books and copyright, because I know that you both have a very strong experience in this area. But for our listeners, I'd love to hear it from you. So we'll start with Sophie.
Yes. So I'm a writer. I've written over 90 books now, and both for children and adults and young adults, mostly fiction, but a little bit of non-fiction as well. And I'm also the chair of the New England Writers Centre. I have been a chair of the Australian Society of Authors and the president of the Small Press Network as well. And I'm also involved with the local sub-branch of the Children's Book Council. I came to Australia from France when I was a child, brought up between languages and between cultures and everything, which has influenced my work a lot, but also has given me an overview of different ways in which literature and writing and the general sort of cultural, social and legal framework around that is done in those different places. So that's me. I'm a graduate, PhD graduate of the University of New England. I also did my Master of Letters at the University of New England. And I did a wonderful creative practice PhD. UNE, can't speak too highly of it. It was fantastic. So, yeah.
And I am a lecturer in law at the University of New England. And like Sophie, I am also a very proud UNE graduate. I did my undergraduate degrees in arts and law with honours in law through UNE, and then went on and did a PhD in law. And the PhD, my passion area is the field of intellectual property and specifically copyright. So most of my research is focused around copyright. And in my PhD, what I looked at was the copyright implications of digitized databases. And it was just before the era of AI had really hit. So I was looking at very fundamental principles in copyright, like what does it mean for copyright to exist or subsist in a work? What does it mean for a work to be infringed? And I was looking specifically at digitized databases. And all those principles that I was learning about and studying and researching have actually become more relevant in the era of AI. And so in recent years, my focus has turned to artificial intelligence and the ways in which it is rocking our world and how the law of copyright intersects with that. So that is really, in recent weeks, I've been looking at voice cloning and deepfake technology and how copyright interacts with that and what sort of basically gaps there are in the law at the moment to protect individuals' identities, basically, their image, their voice and their likeness. But alongside that, I have also been keeping a close eye on all of the infringement litigation that is going on overseas in regards to all of these OpenAI, generative AI companies, and particularly authors like Sophie, and, how at the moment, there's the allegation that these companies have been infringing copyright of authors and basically just scraping all of the books and works that are out there and using that to their advantage to train their data sets, and their generative AI. So that has been another area of interest.
And it's certainly I think something that is being talked about a lot more, but I'm seeing it sort of come in waves a little bit. And I thought, as it is World Book and Copyright Day, the two sort of intertwine together quite strongly. So I'm wondering, I guess, from both of your perspectives, where does the history of copyright even start? Like, I don't have a clue myself. I would hazard a guess that it does have something to do with books and authorship initially, but has since sort of evolved. Maybe you could talk about that a little bit, Wellet?
Certainly. Well, One of the things I do love about copyright is its tenacity, Ash. And when we look back at the evolution, if you like, of the law of copyright in Australia, as it applies to books or as it applies to artistic works or films, what is fascinating is that there are these fundamental principles which have their origins in an era of horse and cart or even before that, yet they are still somehow applicable today. And the tenacity with which they are applied by the courts is the thing that keeps it relevant and going. And so that's been really fascinating for me. And the very fundamental principles, such as the notion of originality, that a work has to be original and it has to have come from a human author. So there must be human authorship. And that's something that, you know, back in the day when people had to actually write books by hand, it wasn't of question really. But of course now in the era of AI and of the tech, it's very much that the argument has been that the tech is actually reducing the work to a tangible form. And therefore it's the actual notion of human authorship is so far removed from the reduction of the work to a tangible form, which is another requirement that human authorship cannot be established. But what I personally find fascinating is that the principle of authorship, principle of originality, the principle of the reduction to tangible form, these are all very old, but they're still relevant at the moment in today's society, despite the way technology is moving on.
Yeah. What's your perspective on that, Sophie, as a writer who's so heavily involved in the legal side?
Well, look, I'm very pleased that we have a legal framework around copyright, around authorship, because when you look back, like you look back at the time of Shakespeare, he had no protection over his copyright. People could just sit in the theatre and write down his plays, and he wouldn't get a cent from anything that was printed. He had to construct a career that had a whole lot of other things involved, like, business share in the theatre, real estate deals, all sorts of things. He's known for having had a good head for business, but he had to do that because otherwise you died in the gutter, basically, because there was no protection for your work. And so authorship was important there. People knew, we want to read a work by Shakespeare, not by some random person necessarily. They knew authorship was important. In the Middle Ages, even, it was important. People put their things on their work. I remember reading about and working on a book that was around the work of Marie de France, who was a medieval poet from the 12th century in France, and she prefaces all her things, "My name is Marie and I am from France," and that was her authorial stamp, But she was unable also to protect her copyright. She depended on the patrons and all that, which was the case until, the 19th century, I guess, when copyright started to become a legal thing. And sorry, Willett, you possibly would correct me on this because I'm not 100% clear on it, but it put the framework around it in a way that couldn't just be ignored. I think the real trouble started. There have always been people trying to pirate things, etc. But the real trouble started with the advent of ebooks, because of the fact that then it's kind of, you could still pirate a print book, but it kind of very time consuming and boring to have to photocopy lots and lots of pages. Whereas with the ebook, it's very simple. And so it started with mass pirating of ebooks, and lots of authors, including myself, had their books taken in this way. And a lot of people, what I found very distressing was that a lot of people, consumers, didn't see anything wrong with that. It's like, oh, you're just doing this as a hobby, so what do you care? You think, yeah, well, if I was a surgeon or something, would you think it was okay to just take my work, to just not pay me? And, so those sorts of things, the ASA, the Australian Society of Authors, and the Copyright Agency have been working very hard on making sure that government and institutions and businesses don't forget about copyright and don't attempt to, to take it. But obviously there's always been shysters around and so on, but the advent of AI has turbocharged that. It isn't new. The pinching, the scraping, the pirating, the giant cut and paste jobs, then it's not new, but it's totally turbocharged. And when you look at the recent one with Meta, there was a big thing about Meta using the work of literally hundreds of thousands of authors around the world in order to train their AI, large language model. Everybody I know had work taken. I had 19 books taken like that, just without permission, without acknowledgement, without anything, as well as short stories, articles, etc. Because they also took the work of academics all over the world. And there's been a huge backlash against that. The Australian Society of Authors, the Australian Publishers Association, and other organisations have joined together to lobby government to put a framework around AI so that that can't happen. The Meta people said, it would have cost too much to get the permission. You think, what? You hugely wealthy tech companies, and they're taking from poor little authors, who were earning below average wages from their work. It's just disgusting. That's my very strong take on it. I just feel, look, I tested AI a couple of times to see right at the beginning when we were told about it and you could check things. And my impression is that from two very strange experiences that I had, that it basically doesn't do the work of an author, really. It, in both cases, it hallucinated very badly. One was asked it to write a biography of me. I got all the factual things wrong. It invented books I'd never written. It changed my date of birth, my place of birth, and everything. All things you could find on Wikipedia in 2 seconds. And then the other one was a guy who approached me to ask me about whether he could use an article I'd written about a certain author. I had never heard of this author. I had not written this article. I didn't understand what he was going on about. And I said to him, did you find this on Google? He said, no, I just asked ChatGPT. And it spat out this thing. And he was so cross with me because I hadn't written this imaginary article, of an author that I had never heard of. And that made me think, look, this is really strange. I mean, it's amusing, but it's kind of awful because basically people are taking on trust those things. And what they're doing to create those things when you ask them to do is they're just scraping this content, but it doesn't mean that they're going to get it right because, in both cases it was completely wrong. So it's really, it's a big issue in many ways. And just very recently, sorry, I'm going on a bit about this, but just very recently there were some illustrators, there's been an illustrator-led thing where they're sort of saying, I'm not AI, I'm a human illustrator. And they produce these sort of slightly imperfect things just to show, this is what being a human illustrator is. Because it impacts art a lot as well. And I think there's a lot of backlash happening amongst creative people. And because it's an attack on copyright, but it's also an attack on the intrinsic nature of creativity.
Yeah. And it's something that, all that you're saying is something that I wholeheartedly agree with. So I feel like I have to apologize for how I'm going to post this next question from sort of a legal standpoint, because I feel like morally speaking, when we look at it, it is immoral and unethical of AI to do this content, the way that they're scraping it and all of that. But from a legal perspective, is it different than to someone, an individual, a human, reading a bunch of books and getting all of this inspiration because the AI is not necessarily repeating what they've scraped word for word? Where does that fall from a legal perspective?
It's a really nuanced question, Ash, and it depends. We have to look at the actual processes of the AI, because this is what the courts will do. We need to distinguish input compared to output. So it's how do the AI companies obtain the input, and what data are they taking and or pirating? Where are they getting it from? So if it's data that it falls into the public domain, they're allowed to do that. They can copy that, scrape it to their heart's content. If it's data like Sophie's books, well, Sophie holds copyright. That's copyright protected. So we have to look at that. And we also have to look at how much of Sophie's work, for example, is taken. Is it 100%? Is it 10%? And we also have to look at how it is used in terms of the training for the input, and also how does it actually synthesize data for the output. Now, what's interesting about these arguments, particularly overseas in any of the litigation, because there's so much. I mean, there's the Authors Guild in America, there's the New York Times. I've been following the New York Times case. It commenced in December of 2023. It's still ongoing. It will be for a long time. What we're seeing with these particular cases, at the moment they've gone through discovery. They're kind of weeding out. There was a whole lot of other issues that were before the court. There were motions to dismiss for those issues. Some have been rejected, some have been approved. So, but what it will boil down to, any of these court cases, is what is called fair use in the US and what is called fair dealing in Australia. And it is an exception to infringement in copyright. And in Australia, our fair dealing provisions are basically more narrower, more stringent than in the US. It's a much broader exception over there. And in Australia, we have specific purposes that are allowed for fair use. So, for example, for the purpose of research and study is a category, for the purpose of reporting news. But there are still limits on what can actually be taken. So in the case of a book, it can be 10% of the book or one chapter, whatever is greater. So you're not supposed to exceed that, and if you do, you're infringing. But in the US, because it's a broader sort of application of fair use over there, there's 4 different factors and 4 elements. And the first is the purpose and the character of the use, then the nature of the original work, the amount and the substantiality of the actual portion that's used, and then the effect of the use on market value. Now, what's interesting, I've been looking at these 4 elements in the context of the New York Times case, and what's interesting is that the New York Times are alleging that, OpenAI, the owners of ChatGPT, are, fundamentally competing with them, particularly in terms of the effect of the use on market value, because they're arguing that people, like Sophie was just talking about this in the example with her, that people are using these, generative AI apps to obtain data and information about a book. Now, whether the actual output of that is truthful is a whole other matter, because these generative AI apps don't have truth filters on them, so that's an issue. But the New York Times are arguing that it's directly competing with their digital services, basically, because people are going to generative AI and not to their website. So they're saying it's actually taking money away. It's taking money away from ad revenue on their site. So that's their argument in terms of the effect of the use on the market value. But when we actually look at what output does, particularly, it's supposed to, and that's the golden word, supposed to synthesize the data. So it's not supposed to directly reproduce the work. However, in some cases, particularly involving generative AI music, there have certainly been the allegations put before the court that the output is directly reproducing music. And if that is so, then that is a reproduction of the original work in material form, and that constitutes infringement. So we just have to see. It's very nuanced. It really is going to be evaluated on a case-by-case basis. It's going to be looking at the actual doctrine of fair use, how it applies to input, how it applies to output, and ultimately whatever court rules a decision on that, whether generative AI works fall and are captured by fair use, that is going to have a profound effect around the world. And so I think it will be something that will be litigated for quite some time. I think it will go on for years. It may even work its way up to the Supreme Court of the US. We'll just have to wait and see. But in the interim, unfortunately, the band plays on, and authors like Sophie are having to deal with having their works used and people asking generative AI about it and getting false information, and unfortunately that will continue.
And it's such a hard thing as well, because I feel like a lot of, especially younger people these days, don't understand why that's so bad. The amount of people I've seen who have gone, oh, I asked ChatGPT to summarize this book that I had to read for my essay. And, it's like we have a website for that. It's called SparkNotes. Like we actually have human-led facilities and resources that do this thing for you. But mentioning the fair trading and the copyright made me think of something else that, has been a huge thing in copyright, and that is the nature of fan fiction.
Yes.
Especially in recent years with, there's been some allegations around authors like Cassandra Clare, alleging that, a lot of her work started as fan fiction that was taken from somebody else. And, for listeners out there who may not be in fandom spaces or literary spaces and have no idea what fan fiction is, to basically summarize it as a short or extraordinarily long piece of work, fictional, written about characters from an existing piece of media, or in some cases like, celebrities and internet personalities. And we're seeing, at least in spaces that I've been on online, more and more fan fiction authors doing what is being referred to as filing off the serial numbers, and changing the characters and things like that, and then publishing it under their own name as their own sort of thing. Like 50 Shades of Grey, for example, is probably the most famous example when it comes to that. It started out as Twilight fan fiction, allegedly. I'm not sure if it's been proved or not, but I guess, I would be curious, for both of you, what your perspective would be from, I guess, the differences of someone writing fan fiction themselves about, a story or a thing, or taking inspiration from that, and then going on to adapt it further and try and, as I said, file off the serial numbers and produce it into something original, how that falls under that part of, originality and authorship and fair use, I guess, maybe from an author's perspective. Sophie?
Yes, well, it is a vexed question, because, of course, we can see that, like everybody says, there's no such thing as an original plot. For instance, they've been around since the Odyssey, and but that's different to actually taking characters and then. But on the other hand, people have also used, like they've legally and openly published works, like, for instance, a new Sherlock Holmes, for instance, which is okay because that is now in the public domain, but also a new Agatha Christie, which is done with the permission of the Agatha Christie estate and so on. So they're using the same characters that as Agatha did, and writing their own. Now, in my view, they don't. Her gift was such a elusive one that you can't really reproduce it properly. It just doesn't feel right, even when it has all the framework and everything. It just something's missing. The magic is missing. But occasionally it can work quite well. James Bond is another one that's been done that. But those are legally permitted, properly done, proper framework, etc. It's up to readers as to whether they like it or not. When you've got, and of course, I've written books that are based, say, on fairy tales and things like that. So a lot of them were from anonymous writers, authors originally. Some of them are by named authors, but a long time ago, And that's sort of an inspiration, but it become something much bigger, because you get from one short fairy tale, you get a whole novel, for instance. Fan fiction has similarities with that kind of thing, but I think that if people go from that, and I think most authors are quite, flattered to have fan fiction written about their books, in the world of their books, and they, especially in science fiction, fantasy, and romance, people are incredibly passionate about the genre and about, the stories and the characters and so on. What the problem happens is when you actually think that you have a right to take that author's characters and story, bend it to your own things, and publish it as your own, because that is not right. That is skirting very close to plagiarism. And because plagiarism isn't just about, copying things word for word, it's also about copying actual, characters in particular. If they're called the same, if they're the same, it's not the same as just having a character inspired by a character. You know what I mean? So it's a very fine line, but most creators know exactly where that line is. You know it instinctively. You know it absolutely, and I think that a lot of people get a lot of enjoyment out of writing fan fiction, but there has arisen this kind of weird thing where fans think they have a right, like it's almost like the author, the death of the author, the author doesn't have any rights anymore. And it's like, well, we the readers, conjured up this thing, and you think, no, you didn't. If that person hadn't written the work, you wouldn't know anything about these characters. Write your own damn thing, you know what I mean? But it's very but it is a very fine line. I agree. It's like there's aspects that are quite okay, and there's others that it's just when it starts to get to the point where people are, and I have seen it happening, like I don't get involved in these things, but I lurk in the background and see it happening, like people sort of insulting authors, by saying, you've got no right to stop me from doing this, or you've got no right. It's like, well, you've got no right to your house. I can take your house, no problem. I decide I like your house better. I'm going to take it from you. How is that different? It's like they don't seem to get it. They don't seem to understand that, the love that they might have for these characters can become like a stalker's love, So they're stalking the story, they're stalking the characters, and they're destroying it in the process in that sense. So, but obviously that's a tiny minority, the vast majority, it's not a problem. So yeah, it's just getting to a feel for what people like to do, I mean, there's always been this thing like in music of remixing and so on. My son does, he's a music producer as well, and he's done a lot of that, but with the permission of the original artist, which is different, and with the kind of the respect for the original work as well.
There is certainly a definite shift, and you might be able to speak a little bit more about this. Well, I'm thinking specifically of Anne Rice, like back in the day, with Interview with the Vampire. She was an author who was so vehemently against fan fiction that she would actually issue copyright takedown notices to fanfic authors who were publishing their fan fictions online, and so that actually, I mean, someone out there has definitely written a whole doctoral thesis on this, on how that completely changed the online nature of publishing fan fiction and the way that people engage with it. And it used to be that people would open it with, I do not own copyright to this. This is a work of fan fiction used under, this specific part of fair use, fair dealing, whatever the country calls it. I don't own these characters, yada, yada, yada. And now it's something that I've seen as well in online spaces. Fans who are being like, well, the author doesn't understand the character like I do. And it's...
yeah, that's right. Exactly.
there's just this complete shift. I don't know. Are you familiar with that sort of the Anne Rice thing with copyright? Well, is that something that
Yeah,
you've
well,
looked
I
at?
was aware of the fact that she was issuing cease and desist notices and all of that. But yeah, I mean, it's a very fine line, as Sophie said, between a person basically paying homage to a book, a fiction or fictional characters, etc., versus them basically wanting to control and take over, and to the point where they're saying that they know the character better than the author does. So, in terms of the challenge with copyright there, or the challenge with the law, of course, and parody falls under this. In order for the fictional characters to be recognizable, there has to be enough detail to make them recognizable. And so you're walking that very fine line of, and I've used the example of Harry Potter before. If you were to write a book and you had a male wizard that had a scar on his forehead, you're walking that fine line. It's like and he's at a magical school that's got a different name to Hogwarts. You're really walking a very sort of rocky path, because you've got elements that are so similar to Harry Potter, where versus the other extreme end, of course, is that you are writing about Harry Potter and other adventures at Hogwarts. So it's a tricky area. And what I find as well, an interesting aspect to me, I always call it the show me the money factor. And when I was doing some research on fan fiction a while ago, yes, authors are very happy to have fan fiction, and they like it because, it means that people are engaging with their characters and that. But as soon as somebody starts to make money from the fan fiction, that is when often it gets messy in the law, because, suddenly it's, it's a problem for the author, because it's basically taking away livelihood from them. So that's interesting. And another aspect of it is moral rights. And I think that, and Taylor Swift, funnily, I did some work on Taylor Swift last year, and she talks about how the works are so precious to her. Like, her music is more than just music. It is part of her. And how when her original catalogue for, her first 6 albums was sold to a private equity firm, and she wasn't even consulted about it, how that was just so personal to her, because it meant so much more. And I looked into, well, how did moral rights play a role here? And, there's 3 moral rights in Australia, and one is the right of integrity. And I'm thinking in the scope and the sphere of fan fiction, there could be a certain line there as to if somebody, a fan, writes a work that is clearly identifiable as a piece of fan fiction, if they do something that basically is so against what an author might envision for that character, I wonder whether there's even a possible infringement of a moral right there. I think that's an interesting thought to ponder. And yeah, so I'm sorry, I'm just musing about different thoughts that have come to mind, particularly as Sophie was speaking. But these are some very, very interesting issues.
Yeah. And you mentioning Taylor Swift actually made me curious as well about how her catalog was sold to a private equity. That would be almost like a publishing house selling the rights to a book to another publishing house without the author's knowledge. Is that even something that happens in the publishing industry?
It can do with less reputable publishers, but usually in the contract, there's a thing saying there will be no assignment of a title to any other entity without the author's permission. But equally, that holds for the author, so that the author can't unilaterally reassign the title to another publisher. They have to ask the publisher to revert rights, and then they can do it. Once the publisher has reverted the rights, you can actually publish with another publisher. But it's a very important part of publishing contracts, is that they can have no assignment without consent.
Yeah. And I guess publishing as well brings me into this, I mentioned Anne Rice, and we're seeing now a lot of further modern adaptations of her works. But then I've also seen on the complete opposite end, the issue of copyright when it comes to estates. So the Tolkien estate, for example, is, I guess, very, I don't know if I should say notorious or infamous for keeping the copyright very, very close at hand in the permission. And I can absolutely understand why, given how integral, I guess, Tolkien's works were to the fantasy genre, and the fact that the estate is made up of his direct family. That's very precious to them. I guess, where when it comes to adaptations and estates, where does the copyright sort of shift? Because I know it's like the life of the author and then X amount of years after their death is my very basic understanding. Where does that happen with estates who then hold the copyright, like the Tolkien estate?
Well, it's actually an interesting example to bring up, Ash. So you're right, it's life of the author plus 70 years. So that's for authors. So what was interesting with the Tolkien estate, there was actually some litigation in the federal court, and it involved, it was a infringement allegation. There was a ring maker. I think he was in either New South Wales or Victoria, and he was creating the One Ring from the Lord of the Rings, and he was putting the inscription of the actual that was made by Tolkien on the inside of the ring. And the estate sued for infringement because it was a direct reproduction of the actual words that were used, but it wasn't words, was it? It was a special sort of language that Tolkien had made up inside the rings. And so it went to the federal court, and yes, they looked at it and found that indeed it was, direct infringement. And so the maker was ordered to cease trading, cease selling the rings, and to destroy all of the remaining rings. So that was, of course, Tolkien's not alive. It was brought to the court by his representatives, his legal representatives, and the estate. So, yeah, it's an interesting one. I mean, obviously, another example that comes to mind with estates is the famous case involving the Kookaburra song, the larrikin music song, song by Men at Work. They were accused of plagiarizing the Kookaburra song, and what they did was it went to court, and the Kookaburra song had a really interesting background. It was written by a lady called Marion Sinclair in about 1934. She died in the 1980s, and she willed the rights to her song to the Victorian State Library. What did the Victorian State Library do? They sold it to a record label. So it's an interesting example there that Marion had long since deceased. It was willed. She wanted it to vest with the library because it's basically, a popular Australian folk song. The library didn't hold on to it. They sold the rights to a record label. And, of course, they were the litigants in the Men at Work action. So, I think that's just a really interesting, example of what can happen with copyright and with estates.
Yeah. I'm also, I feel like, we're coming up to 40 minutes, so I don't want to make this go, too much longer, even though there's such a wealth of conversation to be had on this topic. I invite people to think about that, and particularly, I guess, as you mentioned, the moral rights, and whether or not that specific case infringes on those. If you're a student at UNE or another institution and you're looking at literary studies or copyright studies and law, consider those sorts of things. But I just, before we fully wrap up, I just wanted to invite both of you to, if there's anything else that you'd like to share that I haven't touched on that you think is really important, or, very impactful, something that's meaningful to you in terms of World Book Day.
Yes, well, I think that books are, the most extraordinary form of immortality in a sense. Things we can read, things of people who were alive 400 years ago, and you feel like they're speaking directly to you. We can read things that happened just 2 years ago, and they speak to you. So they are the most extraordinary form, which is actually has gone down through the ages, encoding stories, which keeping on. It's at the heart of the literary creative imagination. Is these words on paper or on screen or whatever, which take you into these extraordinary journeys of the imagination and into other worlds and other times, and so it's a fantastic thing.
Yeah, and I think I would add to that yes, we love books. They're amazing. They transport us to different worlds. And some may argue in this day and age that copyright law is being made redundant through AI and changing technology, but it's the existing framework that we have as we know it. It's what we've got. It is what has been able to work in the past. And I would argue that copyright will remain, it will continue, and it will continue to be, the application of it will continue to adapt, and it will continue in its course of tenacity in that regard. And we're kind of going through, this fourth industrial era, a time of profound change. And there are gaps in the law and there are issues with the law at the moment, but we just have to wait and see how it all pans out. I'm sure it will continue. I don't believe it will be made redundant.
Yeah, thank you both so much. And just a last fun one, a favorite book that people should read?
Ooh, wow, that's a hard one.
Yeah, it usually is.
Yeah, well, what will I say? I guess one of the things that as a child really inspired me and was a book of fairy tales that I read. It was the first book I read in English, and when I was a kid, because I had read in French before, and it just gave me basically the stories that I knew already. They were in another skin, and that skin was language, a different language, and they gave me a different aspect of it. And that actually was something, even though I didn't know it at the time, that I was receiving this kind of thing. That's what's happened for me. And it was a little book called the Blue Book of Fairy Tales, and it was a little golden book, beautiful illustrations. And I often cite it as something that has been an inspiration because it actually enabled me to see those stories in another skin.
Yeah, awesome.
Yeah, I did so much reading as a child. I loved reading. I loved being transported to other worlds. But one of my favorite series of books was the Anne of Green Gables series. Yeah, so that's the one that probably inspired me the most as a young person. But I really love books. I have a big library, and yes, it's certainly they have such a wonderful capacity to expand our imaginations and to enhance our creativity.
Yeah, absolutely. Thank you both so much for coming on and for talking to me. I know they were sort of big questions, but I think the ideas and the information and the wealth of knowledge and experience that you both have is really, really interesting and very vital. And I hope that our listeners learned something and are asking themselves a bit more questions about the nature of copyright and the ethics and morality behind AI and are thinking how they engage and, what sort of books they might like to read and why. So, yeah, I just want to thank you both so much for coming on.
Excellent.
Thanks so much, Ash and Sophie. It's been great.
Yes.
Yeah.
You're all listening to 106.9 Tune FM.